Hello. Thank you so much for tuning into Battle with Ola once again. This is Mujola Olua, and in this video, we want to talk about child custody in Nigeria. Child custody is something that we've talked about briefly on the channel before. There's a short video that I made, a YouTube short that I made on child custody a few months ago. I hope that you've seen it. I'll link it in the description box, but today I want to talk about it, want to expatiate on child custody in Nigeria because someone asked, and in the last video I promised that we're going to talk about maintenance, alimony, spousal maintenance, and then child custody. So this is the second part of the last video. What is child custody? Ordinarily in a family setting, there's a father, mother, and their children. So there are parents and then the children, and the children are in the custody of their parents. That means that the parents have a responsibility to care for and maintain and look out for their well-being. That's what custody means. But when that relationship breaks down, when the family unit breaks down, that is when the two figureheads, the parents, when they go their separate ways by judicial separation or by divorce, dissolution of marriage, what happens to the children of the marriage? That's what we want to talk about today. And the provision that's been made by the law, to cater for the children's well-being is child custody and child welfare. Child welfare often follows child custody. They go hand in hand, and we're going to be talking about them in this video. Don't forget to subscribe to Battle with Ola, like the video, and leave me comments in the comment section after you've seen this video. Don't forget that if you need paid legal consultation, you should book a paid session with me. The link is in the description box. Just click it and book a session, and you'd get to speak with me one-on-one. It's paid for. And also for people who message me from Battle with Ola via my email houseoflivingstones@gmail.com, I want to implore you to please title your mails. Please give your mail a heading or a title, and more appropriately, let it start with Battle with Ola, then whatever you want to discuss. If you want to make an inquiry, for instance, on say motions, you can say Battle with Ola motions or Battle with Ola child custody. Very important. Sometimes I get emails and I'm wondering, why is this person talking to me like they are familiar with me when I can't even remember where I know them from. But if you say Battle with Ola, we know that you want to continue the conversation, so I will quickly get a grasp of whatever it is you want to talk about. Thank you very much. Child custody under the Nigerian law, is catered to or catered for by the Matrimonial Causes Act. The Matrimonial Causes Act. That's the act that talks about marriage and ancillary reliefs, marital reliefs and ancillary reliefs. This would concern or affect children born in marriages conducted under the act. That is, parents who were married under the act. So we're talking about the child custody for children under such or from such marriages. In customary law, there are different ways of awarding custody. Usually, the general principle is that the father is the owner of the child or the owner of the children. So usually, the father would have custody of the children, except, of course, he's unfit to do that. And in some customs, they would even award custody to relatives. And custody could also be awarded to the mother in some instances. But generally, in customary law, the father is the custodian of the children, although the mother will have the day-to-day care of the children. Also in Islamic law, the father is the custodian of the children, but in their younger age, in their tender ages, children under 7, for instance, for males, and under 9 years old for females, are given to their mothers. But outside and above that age, custody belongs with the father. So those are some variations, but the generally agreed principle, which covers both customary Islamic and marriage under the act or marriages under the act, is that custody is awarded considering what the best interest of the child is at the time, the best interest of the child. And that's what the Matrimonial Causes Act says as well, what the best interest of the child is. And there are a few things that can help or guide or serve as pointers, to determine what the best interest of the child is in any particular circumstance. Don't forget that the courts will look at it from case to case. So it's not a watertight process or procedure. I've seen situations where most people or many people have said that in Nigeria, only the mothers get custody of children. So no matter what you go to court to say, the court is biased, they will give your children to their mother or to your wife or ex-wife. It's not always so. If you can prove to the court that you are the proper party that can take care of the children, you have the best interests of the child at hand, at heart, and the things that the court is looking at, you qualify, the court will give you custody of your children. So it's important. And also, under the Act, for marriages under the Act, the court is reluctant to and will not award custody to third parties. So if, for instance, you are coming to claim custody of your children so that you can take them to your mother or your grandmother, or give them to your sister or your cousin to take care of, you might not succeed if the other party can prove that to the court. So you must be able to prove to the court that you in particular, as an individual, you can take care of the children. Because in some instances, the court would even consider, have you remarried, or are you now living with someone, and is this good for the child or for the children? So the best interest of the child is considered. So I've itemized, a number of things that the court has considered in a plethora of cases to determine custody of children, and we're going to go through them briefly and then talk about the types of custody before we go on. The court would usually consider, a combination of these things when deciding custody. And the first thing that the court would consider, of course, is the best interest of the child. Where is the best interest of this child protected? We can look at that in these instances. A 7-year-old girl, and the father is a military officer, the mother is maybe a doctor or a lawyer or a teacher, and now the father, who is on peacekeeping missions, has just come in briefly and is asking for custody. The best interest of the child is to have present parents who can cater to them, especially a 7-year-old girl. So in that instance, the court will consider who can do this best for the child. It's certainly not the father. So that's what the best interest of the child means in this particular instance. The court will apply these rules to the particular instance. So don't go to court with a biased mind thinking, oh, they will grant it or they will not grant it. It depends on the facts before the court, what you can prove to the court. So the best interest of the child is the first and paramount thing that the court will consider. The second thing would be the age of the child. So the way that the court would grant or decide custody for a 7-year-old would be different from how the court would decide custody for a 13-year-old, for instance. For instance, a 13-year-old or an 11-year-old girl, again, who is just starting her menstruation or going into puberty, the court would consider what kind of father does this person have, what kind of mother does this person have, and are they able to cater to the demands of this stage of this person's life, person being the child. If no, of course, the court will not award custody, but if yes. So I've used that to show you that it is not just that the mother, sometimes the father could be the best person to be able to handle or cater to the puberty demands of an 11-year-old lady or girl. So in that case, the court may award it to the father if that can be proven and shown to the court, to the satisfaction of the court. And if the court is so persuaded, the court will award custody as is due. So the court will decide on a case-by-case basis. Another thing the court might consider is domestic abuse or negligence, on the part of both or either parents. So if there's been a parent that's been that has a track record of domestic abuse, for instance, the court would consider that in awarding custody, whether it's the man or the woman. And issues of negligence, maybe it's a parent that would usually take off and disappear, come back after 6 months or 1 year, not caring what the child eats, feeds on, wears, how the child schools, how the child is socialized. So, or even a parent that is around, but that is not present in the life of the child, that just abandons the child to its own whims and caprices. And the reason for this consideration is because parents are legal guardians. So they are holding a trust for God, regarding their children, and holding a trust for the society. So what God wants to teach the children, what the society wants to teach the children, even sometimes what the school wants to teach the children, what every person and every institution that has a role to play in the life of a child, wants to teach or pass across to the child, the parent is to make sure that this is properly communicated and the child is properly socialized. So they are holding a trust, a very important trust. So that is why the court will consider these things before awarding custody. Another thing that the court may consider is the ability of the parent seeking custody to provide for the child financially, emotionally, physically, and mentally. So can you provide, if it's, for instance, a mother that's distressed herself, maybe going through some form of trauma or say insanity, for instance, that kind of person cannot cater to the well-being of the child in this instance. So the court may not award custody after looking at several other factors. So can this person asking for custody provide for the child, cater to the child's well-being emotionally, physically, financially, mentally? The court would consider that. And even medically, the court would consider that before awarding custody. So if it's a father that smokes, that does drugs, for instance, and there's a 5-year-old boy in contention between both parents, the court will look at it. What kind of care can this person provide or guidance to this child in this state of drug addiction or drug abuse? So that will be factored into the decision of the court. Another thing the court may consider is the change of environment for the child. How does it affect the child? Is the child already attached, to where the child currently is? Or will the child be okay with a change of environment? You know that when you are talking about custody, sometimes it may involve an upheaval, putting the child from familiar environments, from familiar territory to another territory. For instance, if a parent now lives outside of town in a different city, the child may need to change location, change schools, change church or mosque, change play group, and so many other things. So the court would consider it. How attached is the child to where the child is currently, the natural habitat of the child for now. How attached are they to that place? And will this uprooting, will it be adverse, to them or not before awarding custody? That will be considered. Another thing the court may consider are the living and accommodation conditions of the parent that is seeking custody. So if a parent is living in a shack, for instance, or in a ghetto where probably they are being pursued by their own landlords, or maybe they are just housing with different people per time, spend 1 week here, spend 1 week there. How do you want to take custody of a child and keep moving about like that? The court will consider your living conditions. Then even if you have a permanent residence, is it good for the child? If you are living in, for instance, an area where there's a lot of miscreants and, there's a demonstrable presence of harmful elements to the child, socially or sociologically, the court may refuse custody. So the court will consider your living conditions. Is it proper? Is it prime? Is it prim and proper for the child? And the accommodation conditions. Is this where a child should grow up? The court will consider that before reaching a decision. Another thing the court may consider is the quality of the relationship between the child and the parent seeking custody. So are you the child's friend ordinarily? Not friend, but as in, do you have a proper relationship with the child? Does the child recognize you as their father or their mother? And do you have such a good relationship that you may seek to continue, or that the child may want to continue with you? The court will look at that, because if you've been a toxic parent, that the child even prays that you should get out of their lives, so to speak, and you're asking for custody, you have to show proof to the court that the child actually has some relationship, some attachment to you. If you've been an absent father or an absent mother and you're coming to seek for custody, it might not be such an easy run for you, because the court is looking at what's best for the child. You cannot, another important thing the court considers is to ensure that both parties are not using the child as a pawn in their game. So if parties are disputing, dispute as adults, but don't bring the child into the equation as, a bargaining tool against the other person. So the court will try to ensure that the child is not a pawn in your game. The child is an individual that should be cared for and looked after by both of you. You owe the child responsibility of care and maintenance, and so the court will consider who can do that best for the child. before granting custody. And of course, the court will consider the wishes of the child. There are so many other things that will be considered, but most of them are already subsumed in these things that we've mentioned. The court will consider what is the wish of the child. So it could come to the court asking the child to come up in court or into the judge's chambers to be interviewed, ask some few questions, a little interaction just to ascertain what the wishes of the child is. I did a mediation once, and both parties were fighting for custody of their children. I had to ask them to bring their children, at the next sitting, and I spoke to the children. They were minors. I had to speak to them alone because Party A was saying that the children told me this about her. She's not proper as a parent to take care of them. Party B is saying that I want my children, I've been taking care of them. They were taught to say those things. So I had to interview the children separately, and we were able to forge ahead. So it's important. The court will consider what is the wish of the child. Of course, a child is not in a place or position to decide what's best for them. But it's also important for the court to get the view or the wish of the child and consider it alongside several other factors before arriving at a decision. And this is what the court does in this type of cases. So some of the things that we've mentioned that are already subsumed into what we've talked about would be the income of the parent seeking custody. Can you take care of the child? The degree of affection you have towards the child, the degree of connection the child feels towards you, where you're living. Can you accommodate a child? Should a child be raised in that environment? Are you trying to uproot the child from familiar territory, and can it be detrimental to their growth and to their socialization, and several other things? So when the court considers that, the court arrives at a decision. But in most cases, the court is usually swayed because of certain societal advices to give children that are still in their very tender ages to the parents that can biologically take care of them the most. That's not the only consideration, like I said, but in most cases, for instance, a 2-year-old child now should go to the mother because that child is still in a very tender age. It's the care of a mother, and the court will not give it to the father for the father to go and give his own mother or his own sisters when the mother is alive. So long as these other factors are not stacked up against the mother, the court may likely give custody to the mother. It might not be permanent custody, it might be up to a certain age, but we'll go into that much later. So this is how the court decides custody in Nigeria. And it's important to, if both parents can come to an agreement, they can present their agreement as to custody, as part of terms of settlement to the court in maybe a dissolution proceeding or a petition for dissolution, and the court, if it's so persuaded that that's the best interest of the child, will adopt it as part of its judgment, in that matter. So parties can agree, and the court can make a decision based on evidence furnished by both parties before the court. Let's now look at different types of custody that we have in Nigeria. Well, we could have divided custody, split custody, joint custody, or temporary custody, as the case may be. Divided custody is a situation whereby the child lives with one parent for a period of time, goes to the other parent and lives for a period of time. Within that period, that parent exercises total control over the care and maintenance of the child. So, especially as to the physical location of the child. If the court has awarded divided custody, for instance, and it has said that this child will be in care of his father for 6 months of the year, the mother cannot go to the child's school behind the father and go take the child. That will be contravening the order of the court. And don't forget that a custody order is like any order of the court. It must be complied with. Failure to comply with it or contravening it is contempt of court, and it's punishable. So divided custody usually would come with visitation privileges. So it will say that, okay, you can visit the child at so time, so places, but outside of the agreed terms, outside of the stipulations of the court order, the parent who doesn't have custody for that period cannot go and do as they please regarding the child. So that is divided custody. Another type of custody is split custody, where the court splits the terms or the content of custody. So one parent could have the daily care and control of the child, physical custody, while the other parent will have custody of life-changing decisions about the child's future, So if, for instance, you wanted to change the child's school, the other parent would have power to decide or to say yes or no to that decision, or to control that aspect of the child's life. But say you're taking the child to school daily, you're looking at the provision of food, shelter for the child, and all those basic daily needs. This other parent that has physical custody will be in care of that. So that's split custody. It could go either ways for either parent. So care and control is granted to one person, and then custody is granted to another person. So that's split custody. Temporary custody is another type of custody. That's the kind of custody that the court may grant pending the determination of a court proceeding, maybe a matrimonial, a decree, maybe a proceeding for dissolution of marriage. So the court may say, until we reach a decision in this petition for dissolution, let the children stay with their father, or let the children stay with their mother. So parties must comply with it, even though they are still awaiting and going through the process of trial to determine the final outcome of the fate of their marriage. The custody order must be respected. So that's temporary. And there's joint custody, which is much more common. Joint custody usually signifies that both parents are compelled by the court to take care of the child. Not 50-50 now, and not like split custody that, okay, you decide on the life-changing decisions, I decide on the daily care, day-to-day care. No, joint custody just means the parents will be responsible for the child together. Not 50-50, but not equally necessarily, but as each person has power and is available. So if one parent pays the school fees this term, the other person they pay the other term. So joint custody connotes that both parents will take care of the child and have custody of the child, maintain the child as they may have the ability to do so per time. So this is the most favorable type of custody because it encourages parties to be partners, to continue their partnership as parents, even though they have ceased partnership as a couple, as husband and wife. So the court will usually grant this type of custody if it's convinced that both parties are able to maintain a healthy relationship as regarding the care of their child or children, even after their marriage has come to an end. So it's different from split custody in the sense that there are no completely delineated responsibilities as to care and control of the child, just as each person sees fit and has the ability to do so. There's third-party custody, which the court can grant in a situation where it determines that none of the parties are actually interested in the welfare of their children, or they are disqualified from having custody of their children by one factor or the other, or if the court finds that none of the parties have actually asked for or are even interested in custody or in seeking or getting custody of their children. This is usually a last resort, and it's very rare, and the court would usually grant this custody to a party that is capable, a third party that is capable of taking care of the child and acting in loco parentis. This could be temporary or it could be permanent. In these instances, in contemporary times, the court would probably send the child to social welfare. The social welfare agency of the state would usually take over the custody and care of the child in this instance. Now, for joint custody, it's important to note that the court will only award joint custody where one of the parents or neither of the parents have been disqualified by any or several factors. That is, if the court finds that nothing disqualifies either of the parents from having custody of the child, the court will grant them joint custody to be exercised jointly. So these are the most important considerations in custody, in seeking for or applying for granting custody in Nigeria. The court will consider, parties must also consider, parties who are seeking custody, what is the paramount interest of the child, or children in question, before seeking for or before granting custody. That's all I want to talk to you about in this video. I will see you in my very next video. Don't forget to subscribe to those.